So you're going through a divorce, and I want you to think about estate planning as you go through the divorce process. I want you to be open to possibilities that exist. So among the possibilities, you could set up an irrevocable trust. This would allow payments to continue on into the future without relying on the ex-spouse or even the agent acting under a power of attorney on behalf of the ex-spouse to make those payments into the future. So this could be in regard to child support payments, alimony payments, even payments in regard to life insurance premiums, and so on. So you really want to be protective and think about future and what is going to be most beneficial in your circumstances. As well as you think about the future, you want to carry out your intentions in regard to all of your estate plans. So you need to look at any wills that you have made, any trusts that you put in place. If you are the beneficiary of another person's trust, that needs to be reviewed and see if any language needs to be changed. Of course, you need to look at your own power of attorney and healthcare proxy and so on. As always, you're reviewing your assets, deeds, business interests, bank accounts, life insurance, retirement accounts, all of the various accounts, and making sure that you have a second set of eyes reviewing everything. Too often I see something that gets missed. Most importantly, beneficiary designations get missed. And so this all needs to be reviewed so that you make sure that your estate plans are carried out with what you want. Now, let's just say in the process of divorce, you have a spouse who passes. What happens then? Well, your divorce attorney may have a separation agreement, and within that separation agreement, there could be a waiver of certain spousal rights. And a waiver is like a contract. And so the language has to be very specific as far as what is being waived. But if there is no separation agreement that has this kind of waiver in place and a spouse passes before the divorce is finalized, then we have a surviving spouse who will benefit from that spouse who passed his or her estate. There are various rights that a spouse has in regard to being a surviving spouse, in regard to assets that will vest in him or her, as well as what's called a right of election. And you could be disqualified as a surviving spouse, and that's per statutory law. And if there's any question there, that issue can be litigated, and surrogate's court has the right to determine if there is or is not a surviving spouse, but we don't want to go there if we don't have to. And of course, we don't want to leave this as an open issue. If we intend to get divorced, we want to see that finalized. Too often people will continue on with their lives, just not really deal with it. And then we have to deal with, do we have or do we not have a surviving spouse? And you can only guess. There are always parties wanting a surviving spouse and parties not wanting a surviving spouse. So very important to think about all of these things. Now, the divorce process itself is very emotional, very difficult. Have your support team. So you're going to have your professional helpers and your non-professional helpers who are just going to help you get through it, provide the support you need, and make as good as decisions as possible, even in this difficult time. If you have any questions, of course, please reach out. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.